Joining us now is Suffolk University law professor Renee Landers. Professor Landers, thanks for being with us.
Thank you for having me to talk about this important case.
Yeah, thank you so much. Let's get right into this here. Roe v. Wade, we know, has been settled law for decades, about 50 years. Talk about the precedent set here with this.
Well, as the concurrence by Justices Breyer, Sotomayor, and Kagan noted, the Casey case, which was the case that kind of reinforced the Roe regime, was a case about precedent as much as it was about abortion rights. And now we've thrown that analysis of when it's appropriate for a court to overturn a precedent out the window. So I think that the court is really signaling here that nothing is safe, despite their protestations to the contrary in the majority opinion today.
Well, let's expand on that a little bit, because we heard a lot today about the fact that the court never before in its history has taken away a right that it has granted as constitutional. It has overruled precedent to grant constitutional rights, but not taking them away. Well, conservative Justice Clarence Thomas today, his concurring opinion, he calls for the reconsideration of a range of cases involving the right to contraception, the right to same-sex relationships, and the right to same-sex marriage. So what do you think? Does today's ruling have implications that the court's going to perhaps go down that road of overturning a bunch of other precedents? Even though Justice Alito said that's not going to happen, Justice Clarence says he thinks it should.
Well, Justice Clarence Thomas's point is slightly different, because he has objected to the doctrinal methodology that the court has used to identify things like the right to contraception, the right to abortion, and the right to same-sex marriage. And so far, he has not gotten any other votes from any other justice on the court ever for this opinion, but he's been beating this drum for more than a decade now. However, I did perceive that his list in today's concurring opinion is an invitation to people to come in and challenge the existence of these rights. And the court in the Dobbs decision today has kind of paved the way for overturning them, even if they don't use Justice Thomas's preferred methodology.
Okay. We know also just yesterday, the court ruled on another big case, saying all Americans have a federal constitutional right to conceal carry a gun. But today, the court ruled against a federal right to abortion, leaving that up to the states. You know, for folks who are following all this closely, which is everyone, why are the two rulings so seemingly opposite?
I think they're very result-oriented. I think the conservatives and the Federalist Society, that has been the major generator of Republican judicial nominees for the last several Republican presidential administrations, who've really controlled these appointments to the court, have had this idea of, states' rights on the one hand to regulate personal behavior like marriage, abortion, contraception, and on the other hand, a general federally protected constitutional right, to have whatever gun you want. And so I think that they are logically inconsistent, but I think that this has been, kind of an agenda of the certain Republicans for decades now, and they now have the nominees on the Supreme Court to make it happen.
All right, Suffolk University law professor Renee Landers. Professor, thanks for your time this afternoon.
Thank you very much.
All right. So